Trespass to land can be claimed even if there's no actual damage caused. The essence of the tort is that the person in possession has the right to decide who can and who can't come onto the land which they possess. The dispute in Rodrigues and Ufton was about a strip of land less than a metre wide which ran between their properties and which was originally designed to give Ufton access to a road at the back of both properties. At some point more than 20 years previously, a prior owner of Rodrigues' block had fenced in the strip, and nobody objected until eventually, more than 20 years later, Ufton knocked down Rodrigues' fence and put up his own, excluding her tenant from the land. She sued in trespass, claiming title to the land and damages. However, by the time the dispute occurred, Rodrigues was no longer in possession of the land. She had long since leased the land out to a series of tenants. Ufton's lawyers argued that regardless of the history of the land, Rodrigues couldn't bring an action in trespass because trespass protects possession and she wasn't in possession of the land. Reading the case, Justice Hodges clearly seems to have thought this argument was just a bit too clever. He split the issue up into the question of title and the question of damages. On the question of title, he found no problem. He said she was in possession by her tenants at the time that this action was commenced, and the persons holding that property had been in possession of that strip of land for a period of 20 years and upwards. On the question of damages, however, things were more interesting. The judge found that usually, if damages were due for trespass to property, those damages could only be claimed by the person in possession. The exception was if the harm caused to the land would cause harm to the reversioner, the person who would resume possession at the end of the lease, in this case Mrs. Rodrigues. He said that a reversioner can bring an action and can recover damages if a trespass will injure his reversion. Having made the point of principle, however, Justice Hodges clearly felt the injury, if any, was marginal. Instead of the £250 which had been claimed, he awarded damages of just £1.